Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. Looking for ways to keep calm and serve your clients? With the state of immigration law today, I bet I know the answer. Well, on September 30th, the podcast friends at e-immigration are hosting a live webinar with performance psychology expert Nikola Milankovic that's all about stress management. It's not just your typical just breathe session. You'll learn practical tools rooted in psychology and high-performance coaching, how to manage self-talk, control your attention, and create a culture that supports resilience. Go to get.eimmigration.com/events to save your spot, or click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Greetings, nerds! Before getting to the cases, some updates, as always. Seems like the First Circuit has vacated the lower court's preliminary injunction barring the Trump administration from terminating all the paroles. Not gonna lie, I thought that issue was already decided, although maybe it was just like a shadow docket thing on the preliminary injunction. That's just Svetlana Dovey Noam litigation, and it seems nearly done. Seems like it's on its last legs, despite some very hardworking and smart attorneys. Also seems like the Ninth Circuit ordered the U.S. government to do some stuff with refugee resettlement. Never a dull moment in immigration litigation with the Trump administration in office. Shout out to all the private bar attorneys going into battle every day, getting little sleep, moving mountains to get their detained cases ready for merits, learning and filing habeases, and doing all the things. We are that first line. It is a lot, it is so much, but we're kind of the bomb. Some cases for your arsenals. Our first case is Hewitt v. United States, published by the United States Supreme Court on June 26, 2025. This is a decision that I've been holding for a while. Ira and I discussed it briefly on the Supreme Court Roundup a few weeks ago. Or was it a few months ago? It's getting hard to remember. I myself was alerted to it by a podcast listener, David Satnarine, and so thank you, David. And while given it's a short week with nothing but non-citizen bad decisions, let's kick off the episode with some creative legal arguments based on Supreme Court precedent. This is a First Step Act criminal case authored by Justice Jackson, and it seems like she only has a majority for parts 1 through 3 of her 5-part decision. Justice Alito and 3 other justices dissented. So what do those first 3 parts say? Donald Trump did a lot of bad things during his first administration, in my humble opinion, but the First Step Act was not one of them. Credit where credit's due, and I doubt a Democrat president could have got that passed. That bill took away some very harsh federal sentencing provisions that would sometimes result in sentences to, quote, decades or even centuries, end quote, in prison, and as relevant here when an individual possessed a firearm while committing other crimes like a crime of violence. Such individuals still go to jail, don't get me wrong, but now it's not always essentially for life, as it used to be, as I understand what's happening. The question in this case here is, quote, what penalties apply when a Section 924C offender has been sentenced as of the Act's enactment, but that sentence was subsequently vacated, end quote, that statute being possession of a firearm federally. As such, this decision has potential implications for vacating convictions through federal law, which, dare I say, includes immigration. It is, after all, the Supreme Court talking. And when it talks about vacature, we should listen. The First Offender Act provision is actually partially retroactive, another very favorable thing for certain criminal defendants that Congress and President Trump during his first term passed. Enter Mr. Hewitt and others who robbed a bunch of banks with firearms and were convicted in 2009. So well before the First Step Act, right? For those offenses, because of the prior stacking rule before the First Step Act, Mr. Hewitt and his co-defendants were sentenced to over 325 years in prison. I'm sorry, that's just absurd. They got it down to 305 years on appeal, though, so there's that. Now, that was all based on a finding that Mr. Hewitt committed one or more crimes of violence with a firearm, the bank robbery. Sound familiar? Crime of violence? But the Supreme Court found that sentence enhancement definition unconstitutionally vague in 2019. I believe just before, or maybe just after doing a similar thing in DiMaia for the similar immigration crime of violence term. At least Section 16b. So portions of Mr. Hewitt's sentence got vacated, by which point the First Step Act did apply. The Supreme Court here ultimately agreed, which is very good for Mr. Hewitt and his co-defendants, and lots of it is based on statutory analysis very specific to the First Step Act. That is, they're going to get to benefit from the First Step Act and probably get a lot of time off their convictions. So why is this possibly relevant for immigration? Well, first, in speaking about the First Step Act, the Supreme Court majority states that Congress legislates things like the First Step Act and the I&A, I guess, under the backdrop of certain presumptions. Quote, one such presumption is that vacated court orders are void ad initio and thus lack any prospective legal effect. By operation of legal fiction, the law acts as though the vacated order never occurred. End quote. That sounds pretty clear and direct, in contrast to what the BIA has held in matter of Pickering and the Attorney General in Thomas and Thompson. Indeed, quote, a criminal defendant whose judgment of conviction has been vacated, for example, is to be treated going forward as though he were never convicted, end quote. And that's what we're talking about with crimmigration, right? Criminal defendants who happen to be non-citizens. The Supreme Court gives an example, too, explaining how, applying this principle, a criminal defendant with a vacated conviction would not suffer civil penalties based on that conviction that had been vacated. Like immigration, right? Despite all its very criminal trappings, everyone agrees that immigration and immigration detention is civil. Quote, that vacated conviction is subsequently treated as no conviction at all, end quote. No discussion about the reasons why one of these convictions is vacated, as the BIA and the Attorney General would have us believe is important. And how many quotes do you guys want me to do here? Returning then to the First Step Act issue at hand, but still relevant to immigration, quote, a judge would thus correctly conclude at resentencing that if an offender's past sentence has been vacated, a sentence has not been imposed upon the offender for purposes of the First Step Act. Hence, the court can impose a new sentence today, end quote. That's the end of the majority analysis in this case, which makes it the end of the binding precedent. As I mentioned, Justice Alito with 3 other justices dissented in full. Justice Alito complains of the broad application this part of the opinion has in his dissent, and well, who am I to disagree with Justice Alito? So thank you, David, for identifying this case. As David persuasively writes to me, for immigration purposes, Pickering and the precedent that follows, quote, have seemingly also placed the burden on petitioners to show the reason for the vacature. This decision seems to do away entirely with Pickering's analysis of examining the underlying reasons for a vacature, end quote. And burdens, I guess. Indeed. Interesting stuff. Further consequences and how it'll apply in immigration to be seen. Make the arguments. And that is Hewitt v. United States. BIA is talking, it always is. First, matter of Garcia-Flores, published by the BIA. The Attorney General has found another unpublished case to make precedential. This one's about discretion, involving a pro se non-citizen who is possibly litigating this himself from immigration prison. And it involves sexual crimes against minors, very complex statutes. And who knows what kind of evidence the non-citizen provided. But how about this opening? Page 1 in the first footnote, quote, we reject the respondent's argument that DHS's alleged failure to mail the notice of appeal to him violated his right to due process. The notice of appeal indicates that it was mailed to him, end quote. If that isn't flawless logic, BIA, I don't know what is. By the way, as someone who has been on the non-receiving end of a DHS filing that DHS said was mailed to me, I feel you, Mr. Garcia-Flores. I feel you. They are not infallible, no matter what their certificate of service says. By the way, and then I'll stop, but a different precedential matter of Garcia-Flores from 1980 is a very important decision that everyone should reread. Okay, this Garcia-Flores. He was convicted of indecency with a child and sentenced to 5 years in a Texas prison. Looks like he's a lawful permanent resident, and now he's removable. He applied for LPR cancellation removal under I&N Section 248A, which he was eligible for. But as with almost all forms of relief, LPR cancellation is discretionary. An immigration judge granted the relief. DHS appealed. The BIA hates it. To the BIA, the IJ, quote, exceeded his authority, end quote. How, you ask? The IJ is, after all, a judge. Or that is what we've been told for decades. Well, to the BIA, the excess authority committed by this IJ was, quote, to consider the circumstances of the respondent's conviction by making an adverse credibility finding regarding the respondent's 2 child victims, end quote. Now, we all know that IJs can't go behind a conviction to determine removability or whether or not a non-citizen committed the crime. And even the BIA concedes that, quote, the facts and circumstances of a criminal conviction may be considered in assessing whether a respondent merits discretionary relief, end quote. Apparently, though, only when they're used to deny relief to non-citizens. The error here to the BIA was that, quote, the authority to consider the facts and circumstances of a criminal conviction in a discretionary analysis does not include the ability to acknowledge legal guilt, but find factual innocence, end quote. That's how the BIA is styling what the IJ did here. This decision is scant on description of what the IJ actually did, so I'm not sure if that is what the IJ did, but that's what the BIA is saying that the IJ did. So then, reviewing the issue of discretionary eligibility de novo, the BIA held that, quote, the respondent's positive employment, educational, familial, and personal equities do not outweigh his jury conviction for indecency with a child, where the jury found that while working as a middle school teacher, he caused the buttocks of a child under 17 years old to tell, you know what, I'm not going to do it, end quote. The things the BIA causes me to say on this podcast. The child was quite young, by the way. Mr. Garcia-Flores went to trial and has always maintained his innocence, though, but he did lose at trial. Catch-22 for Mr. Garcia-Flores then, right? Quote, the respondent has not acknowledged his guilt or shown remorse, and his claim of innocence is inconsistent with the jury verdict, end quote. But, what if he is really innocent despite the verdict? He's supposed to lie in immigration court? Given it all, the BIA does not see, quote, sufficient evidence of rehabilitation or sufficient unusual or outstanding positive equities to overcome the serious negative discretionary factor of his conviction for a sexual offense involving a child, end quote. So he's getting removed to Mexico. And there's this. How about this footnote from the BIA? Quote, we note that the respondent has a pending collateral attack on his conviction in the Texas courts arguing ineffective assistance of counsel. This does not affect the validity of his conviction for immigration purposes, end quote. Citing matter of Thomas and Thompson. What do you mean, BIA? That it doesn't affect the validity of the conviction because the collateral attack is pending? Or that it doesn't affect the validity because it's an ineffective assistance of counsel-based claim, thereby upending decades and decades of precedent in a footnote? Because that Thomas and Thompson cite would seemingly have nothing to do with the former. It is simply astonishing to me that the BIA is publishing decisions with ambiguities and left open questions of this magnitude, seemingly month after month. It feels intentional. Also, I will state, there is another way to defend this appeal. The BIA would have you believe that we're in de novo land because it's simply about discretion, and they framed the issue as a legal one regarding going behind a record of conviction. But another way to litigate this would be to argue that the IJ made a credibility finding in Mr. Garcia-Flores' favor, something much more difficult for the BIA to overturn. Having chosen to make precedential a decision litigated by a pro se respondent, I'm pretty sure the BIA did not have to tangle with this potential hurdle to issuing the decision that it and the Attorney General wanted to issue. And that is matter of Garcia-Flores. Sticking with the BIA, matter of HAAV, that one. This administration's war on asylum continues. This decision is about asylum. The BIA held in 7 pages that IJs can simply pretermit asylum, withholding of removal, and Convention Against Torture applications without holding a merits hearing, under certain conditions. Here's why. Mr. HAAV is an asylum applicant with a claim so allegedly insufficient that the IJ and the BIA are not even giving him a hearing on his claim. Yet they are still protecting his identity and using an acronym. He is from Peru and filed an application for asylum and related relief and protection in removal proceedings. He conceded removability, and at a second master calendar hearing, DHS moved to pretermit that application, which you best believe it's going to be doing all the time now. An immigration judge granted that motion, and the BIA has affirmed. The statute itself, that is the INA, provides that a non-citizen in removal proceedings, quote, shall have a reasonable opportunity to examine the evidence against the non-citizen, to present evidence on the non-citizen's own behalf, and to cross-examine witnesses presented by the government, end quote. To the BIA, quote, these provisions, however, do not require a full evidentiary hearing if there are no factual issues in dispute, end quote. Kind of like summary judgment in federal court, I suppose, but before any party has really submitted any evidence, much less all the evidence, in a case, and without any briefing. Very unlike federal court. So summary judgment, but without all of the attendant due process protections. The BIA explains that IJs have, quote, broad discretion to conduct and control immigration proceedings, end quote. Then, citing to its very recent decision, a matter of KARR, the BIA explains that IJs need not conduct full hearings on incomplete asylum applications. Okay. The BIA then analogizes to motions to dismiss in federal court. Although with a 12b6 motion to dismiss for an insufficient complaint, the dismissed party almost always receives another opportunity, and often multiple opportunities, to amend their complaint and remedy the perceived deficiencies. So I'm not going to lie, BIA, I'm not quite buying your motion to dismiss and summary judgment analogies. Yet, explains the BIA, where an IJ believes an asylum claim is legally deficient, the IJ can just pretermit it. Here, the IJ had a, quote, abbreviated hearing, end quote, whatever that means, to investigate the asylum claim. The IJ confirmed that there were no factual disputes, whatever that means. And quite frankly, here's the meat of it, quote, the respondent's counsel did not articulate any particular social groups for the immigration judge to consider and did not present any reasons why a full evidentiary hearing was necessary, end quote. So, counsels, be prepared at that very first master calendar hearing. Have something. Moreover, quote, the respondent's claim is based on extortion by criminal gangs, and the United States Court of Appeals for the Fifth Circuit, in whose jurisdiction this case arises, has repeatedly held that it does not recognize economic extortion as a form of persecution under immigration law, end quote. But I mean, come on, guys. You know there's a way to frame these things based on the specific facts of a case that may align with favorable circuit precedent, even in the Fifth Circuit. So I guess come to that first master calendar hearing with at least one germane circuit citation, too. Taken all together, the BIA holds that a full-on merits hearing isn't required in such cases. The BIA also explains that the non-citizen had a reasonable opportunity to present his claim because he was represented by counsel. So that would seem to be a prerequisite to the BIA's rule that it's now creating, but I wouldn't count on it. Indeed, the BIA gets at that at footnote 5. Now, I will admit, I wrote what I'm about to say before I read this full decision, counting on the BIA not mentioning matter of facie. But the BIA did. So this is what I wrote. The BIA's 1989 decision, matter of facie, holds that, quote, at a minimum, we find that the regulations require that an applicant for asylum withholding take the stand, be placed under oath, and be questioned as to whether the information in the written application is complete and correct. We would not anticipate that the examination would stop at this point unless the parties stipulate that the applicant's testimony would be entirely consistent with the written materials and that oral testimony would be believably presented. In the ordinary case, we consider the full examination of an applicant to be an essential aspect of the asylum adjudication process for reasons related to fairness to the parties and to the integrity of the asylum process itself. There are cases where a non-citizen establishes eligibility for asylum by means of his oral testimony when such eligibility would not have been established by the documents alone, end quote. Matter of facie, 1989. How to distinguish that? Well, first off, the BIA conveniently did not quote that last part that I quoted. Why not, BIA? But also to the BIA, matter of fact, relies on an outdated version of the INA and regulations. But not that last sentence I quoted, that's just fundamental fairness. To the BIA, though, it all means that, quote, matter of fefe is no longer binding precedent, end quote. Coming from matter of fefe. Careful what NTA allegations you admit counsels. Quote, the ability of IJs to act on facts conceded by counsel is well established, end quote. The BIA also sees no due process violation here. The BIA rejected Mr. HAAV's argument that the IJ was not acting as a neutral arbiter. After all, the BIA just said that the IJ was allowed to do this, explains the BIA. Concluding then, the BIA holds, quote, if the factual allegations underlying a claim for asylum, withholding removal, or protection under the CAT, viewed in the light most favorable to the respondent, do not establish prima facie eligibility for relief or protection, an IJ may pretermit the applications without a full evidentiary hearing on the merits of the claim, end quote. But remember the low bar for establishing a prima facie case from matter of LOG and circuit precedent discussed on the podcast, and be ready at those first hearings. Be prepared for full-on factual and legal argument at the first master calendar hearing, a situation that you won't find in any other court of law. This is the world the BIA desires. And that is matter of HAAV. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Welcome back. With Myers v. Bondi, published by the 8th Circuit on September 8th, 2025. This case is about derivative citizenship. Mr. Myers is from Liberia and was adopted at 7 years old. His mother then got a green card, and he entered the United States as a derivative lawful permanent resident the next year at 8 years old. Then his adoptive mother naturalized in 2004 when he was 15. He claims that his adoptive mother abused him sexually for many years. Mr. Myers obtained a significant criminal record as an adult. He represented himself in removal proceedings and, making some fairly complex arguments, did not succeed. Much of it regarded his own mental competency and, of course, citizenship. Mr. Myers obtained counsel after he lost to the BIA, who moved to reopen based on similar arguments and others. The BIA denied the motions to reopen, and Mr. Myers was removed to Liberia in 2023. The Eighth Circuit affirmed it all. The Eighth Circuit first addressed citizenship. Even though Mr. Myers has lost his claims before USCIS before, a circuit can't just affirm the removal of a U.S. citizen, explains the court in so many words. Actually, lower. If there's a material issue of fact about it, a circuit properly sends it back to a district court to decide it all. Unmet here, though. Under the relevant derivative citizenship law, the child must be, quote, residing in the United States in the legal and physical custody of the citizen parent pursuant to a lawful admission for permanent residence, and, quote, when the relevant thing happens, here the naturalization of the mother. It seems USCIS didn't believe that Mr. Myers was actually living with his mom when she naturalized when he was 15, but there's a material issue of fact there, explains the Eighth Circuit, because Mr. Myers claims that he did. But here's the thing. Under the I&A, derivative citizenship only applies to a, quote, child, end quote. And a child adopted by a United States citizen parent only in specified circumstances, i.e., quote, if the child satisfies the requirements applicable to adopted children under I&A Section 101B1, end quote. That in turn requires that the adopted child, while under the age of 16, have been in the, quote, legal custody of and resided with the adopting parent or parents for at least 2 years, end quote. Now, apparently, Mr. Myers didn't even argue that he had satisfied this, so clearly there are some complicated family things going on here that the decision doesn't get into. Quote, he contends rather that the 2-year custody and residency requirement is unconstitutional as applied to a child who was abused by the adoptive parent. He observes that Congress in 2006 created an exception to the 2-year requirement if the child has been battered or subject to extreme cruelty by the adopting parent, residing in the same household, end quote. Interesting. And of course, that makes sense, right? But the law, that is this VAWA exception, didn't come into effect till 2006. Here, Mr. Myers' relevant time is 2004, when his mom naturalized and he was 15. So literally, Mr. Myers would very likely be a citizen if Congress had passed the law 2 years earlier, or maybe if he was 2 years younger. But neither of those things are the case. Quote, although it could have argued that the line should have been drawn at a different point, it is not the proper role of the courts to probe and test the justifications for the legislative decision and substitute our political judgment for that of Congress, end quote. So that was that on the citizenship. Behold the power of Congress. Addressing then the motion to reopen, well, Mr. Myers was in trouble as it was predominantly based on a derivative citizenship claim that the Eighth Circuit just rejected, right? Particularly as, observed the Eighth Circuit, Mr. Myers never presented new and previously unavailable evidence about his residence with his mother after she naturalized. Concluding then with his mental health claims. Mr. Myers challenged the IJ and BIA's, quote, determination that he was mentally competent to participate in removal proceedings pro se without safeguards, end quote. Probably wants an attorney. But the BIA styled that as a motion to reconsider because Mr. Myers brought the arguments before, and having so styled that the motion was untimely. The Eighth Circuit was fine with that. The Eighth Circuit then quickly rejected Mr. Myers' asylum and withholding of removal claims because in his motion to reopen he hadn't explained why he wasn't barred due to his criminal history. Then, concluding, the Eighth Circuit rejected Mr. Myers' claim that the BIA abused its discretion by failing to reopen his case when he had a T visa application pending based on the abuse he had suffered from his mother. Because see, here's the thing, quote, to be eligible for a T visa, an applicant must be physically present in the United States or certain of its territories, end quote. Liberia doesn't cut it. And so USCIS denied Mr. Myers' application once ICE, within the same agency as USCIS, decided to remove Mr. Myers, thereby preventing him from a T visa. And for this reason, the Eighth Circuit deemed reopening on this basis moot. Sad case. And that is Myers v. Bondi. Conclude with the Fifth Circuit and Garcia-Morin v. Bondi, published by the Fifth on September 12, 2025. So the Fifth Circuit published this decision after I did that Supreme Court decision, thinking that it was a slow week. Such is the Fifth Circuit's wont. This case is about motions to reopen, and I am very tired. Mr. Garcia-Morin is from Mexico and has been a lawful permanent resident since 1982. Should have naturalized. He didn't, and was then convicted of aggravated assault with a deadly weapon. Very scary convictions, to be honest. and he was ordered removed as an LPR convicted of certain firearms offenses. While on petition for review to the Fifth Circuit, Mr. Garcia-Morin filed a motion to reopen based on the Supreme Court's Bondi decision, which admittingly is a bit confusing to me, given that his removability was based on his conviction for a firearms offense, not a crime of violence, which is what Bondi is about, which is what the BIA held. Now, to be fair, it seems he no longer had an aggravated felony because of Bondi, so he was claiming he was eligible for, I guess, LPR cancellation, which technically maybe he was, but the BIA didn't see Bondi as a sufficient exceptional situation warranting reopening. So it denied the motion to reopen. Mr. Garcia-Morin then filed a second motion to reopen, which the BIA also denied. The Fifth Circuit affirmed, mostly about that second motion to reopen. It was number barred, quote, an insuperable statutory obstacle, end quote, to his succeeding. Mr. Garcia-Morin, however, asserted that the one motion to reopen statutory requirement is itself subject to equitable tolling, just like the time deadline to file a motion to reopen. In support, he notes that the time bar to motions to reopen is subject to equitable tolling, which is true. Using flourishing language, the Fifth Circuit was not moved at all. Number bars are very different than time bars. Number bars are substantive restrictions and are akin to res judicata rules. And those rules have no equitable exceptions, explains the Fifth Circuit. Not true. All courts, including the Fifth Circuit, appear to agree that the number bar is now a claims processing rule, and some circuits have held that as such, equitable tolling can be available. News to me. Second Circuit in 2000 and 11th Circuit in 2013. And the Ninth Circuit has held that due process requires it, that is, equitable tolling of the number bar, at least when ineffective assistance of counsel is at play. Interesting. But the Fifth Circuit was not swayed by that precedent. Heck, quote, our court has held that the due process clause doesn't apply to proceedings involving motions to reopen at all, end quote. Gotta love the Fifth. And for those reasons, the Fifth Circuit dismissed and denied the petition for review. And that is Garcia-Morin v. Bondi.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.